Okay, Tim, would you like to kick us off?
Thank you, Bill. Good afternoon, everyone. On behalf of Trust Mediation and my three fellow directors, welcome to this webinar on preparation for mediation. As mediators specialising in personal injury and clinical negligence claims, we see parties at mediation who clearly are extremely well prepared, and others perhaps not so. And today we're going to offer some practical guidance about mediation preparation, something which we regard as absolutely key to a successful outcome of mediation. Just before we start, though, I'd like to mention that the last of our autumn series of webinars is going to be held on Wednesday, 12th of December at 1 p.m. usual time, and that will be on Does ADR work in personal injury? Is a JSM the ceiling for personal injury ADR? So if you receive the flyer for that and have colleagues dealing with personal injury claims, or you deal with them yourself, please pass that on. Our running order today, we're going to start in a moment with Phil, who's going to talk on preparing the client for mediation. Paul will then deal with position statements. Andrew will then talk about the joint open session, and I will deal with the role of the defendant representatives at mediation. If we have time, then Phil will close with negotiation strategy and preparing that. We do, as ever, welcome your questions. And if you have a question, if you would please put it in the Q&A, and we will see that come in and deal with your questions as we go along. Phil, over to you on preparing the client for mediation.
Thanks, Tim. Just before I get going on that, just a call back really to our a previous webinar we did on the October changes to the CPR, and we'd just be interested to know from you if there's any impact of that. So I've just put up a couple of questions on the screen. I'll leave them on for 10 or 15 minutes or so. If you get the chance to pop an answer in to those, we'd be interested to hear from you. And a reminder, just to repeat what Tim said, if you've got any questions at all arising from any of the discussions that we have, just please fire them in on the Q&A, and we'll try and deal with them through the course of the webinar, and certainly at the end if we haven't dealt with them before now. So I'm talking a little bit about preparing clients for mediation, and my colleagues will chip in at relevant points. And one of the first things that we need to do, or you need to do, is to explain to your client the purpose of the mediation and the nature of the mediation, and the fact that it's not a trial, it's not a mock trial, it's an assisted negotiation. It's assisted by an independent person, i.e. the mediator, who's trying to help you and your client and the people in the other room to reach a resolution which both sides can accept. That's the difficult bit, because it's got to be both sides. So the mediator isn't a judge who's ruling on the case and telling the parties what they should be. The mediator is trying to help the parties to find their own resolution to the matter. And this is why it's important to explain to your clients the nature of the meeting rooms. So each party will have your own private room, whether we're in person or online. You'll have your own private room for you and your colleagues and your client, which the mediator can come into and speak to you privately. And you'll hear the mediator say this at the outset, but it's something, and often repeat it a couple of times as they come back into the room, to repeat to your client that whatever is said in that room stays with the mediator and isn't passed on to the other side, not without express permission to do so. And it's important that clients understand that, and hopefully buy into that, because that then enables them and you to speak perhaps a little bit more frankly to the mediator, and to share with the mediator things that you obviously otherwise wouldn't do. And we often, you'll have heard us say on these webinars before that if you can do that and include the mediator in your discussions a little bit more than you perhaps would feel comfortable doing usually, It does help us to help you. And if you've worked with me at a mediation, you'll know I may have delivered an offer into your room, and then often I'll invite myself to stay in the corner quietly and listen into your discussions and deliberations. And sometimes you say, no, get out, and off I go. At other times, you do allow me to sit in. And that just helps us to learn about the case and to learn how we can assist you, particularly later on when the negotiation is perhaps stalling or slowing down. You should also invite your client, whether it's an injured lay client or whether it's perhaps a GP who's attending as a defendant, invite them to speak to the mediator before the mediation. Usually we can arrange a Zoom or a Teams call. And we always make this offer. It doesn't always get taken up, but we make the offer nonetheless. And this is for the client to ask any questions they may have about the process. We don't generally talk much about the case itself, but rather the process of the mediation. And we can explain the things about confidentiality, etc. And it can also, if a client's anxious about the process, as often they are, then it can just help with that by breaking down one barrier. At least they've met the mediator before we start. Ask your clients, particularly claimant clients, if they want to have any particular input or say at the mediation. Do they, for instance, want to make an impact statement, or do they want to have it read out on their behalf? And Andrew's going to be talking a bit more about that in his talk, but it's certainly something to flag up at this point. And ask, are there any extrajudicial matters as well which want to be dealt with? Apologies, explanations about the process, and if it's the defendant side, consider if you're prepared to make an apology, who's going to be making it, what are they going to say, and how best to deal with that. Always ask your client what they want to achieve at the mediation, and when I talk about negotiation strategies later on, I'll come back to this again, but it may well be something different to what you think they can or should achieve at the mediation. And of course, always get authority to deal with any, to reach the settlements that they're trying to achieve. Talk through your negotiation strategy. As I say, I'll come back to this at towards the end of the webinar, but at least explain it to your client, run through it with them, get their buy-in, and of course, if you're the defendant and you need an authority limit, then make sure you've got that ready on the day with procedures in hand if you need to go beyond that position. And explain, particularly to lay claimants, why any potential settlement figure may be significantly different to the figure on the schedule. So the can be very difficult if a claimant attends a mediation thinking that the settlement value at the top level of the schedule is £1.5 million, and in fact all the legal representatives are thinking more like £500,000. And that's a big chunk for them to have to deal with, and it's better not to have to learn that on the day of the mediation. So get that preparation done as well. If you're in person, just some logistical things. Check that there's the accessibility at the venue and any dietary needs. Do you need to stagger arrival times? Is your client anxious not to meet with the other side? And make arrangements for that. What are you going to do if the mediation runs over the planned time? Are there any childcare issues that need to be considered? Parking, travel, all those sorts of things. If you're mediating online, then I've already discussed the possibility of testing out the Zoom or Teams platform with your client in a pre-mediation call with the mediator. If that's not going to happen, just make sure your side is comfortable with whichever technology is being used. It might be, for instance, that the lighting, often you'll see somebody in their living room with the windows right behind them, and because of the light position you can't see the face or any expressions, etc. So it might just be worth just testing that out as well. The pre-mediation discussion with the mediator, this is you as the legal representative, rather than necessarily the client, but you as the legal representative. This call, which we always insist on having before the mediation, is a critical part of the preparation. And I think we've gone into some detail with it previously, but just a couple of points in the short amount of time I've got today is to tell the mediator what has prevented settlement so far, and how you think that might be overcome, and highlight any sensitive issues that the case has. For instance, there might be a life expectancy issue. Does your client, if it's your claimant client, does the claimant client want to have that discussion with you, or would they rather be outside of the room? They don't want to hear that kind of thing. So highlight any issues like that. Try and tell the mediator how you would like the mediator to help you, and there may be many different ways. It might be, for example, that your defendant client or your claimant client doesn't accept the advice that you're giving about potential settlement figures, and you may need some assistance with that, and you can get that from the mediator, but let them know, of course, in advance. And I think I mentioned earlier about extrajudicial remedies. If there are any sought or being sought in the case, then have a discussion and prepare for that. So, conscious of the time, I'll just check with my colleagues if there's anything that they would like to add or ask on any of those issues.
Well, I'll just chip in on one point. You mentioned that the phrase assisted negotiation. I sometimes think that can be misinterpreted as meaning that the parties negotiators, the parties' legal representatives, somehow need some help in what they do. And of course, they're experts and specialists because they do this all day, every day. And to me, assisted negotiation is simply nodding to the fact that the mediator, as an independent, neutral third party, is a catalyst involved in that negotiation. And where negotiations can sometimes get stuck, the mediator, who's been in both rooms and knows the agenda of both parties, can help get it going, can offer a different perspective, can ask some questions. And what might have been an impasse can then move on into another stage, and sometimes the final stage. So that is really what he meant by assisted, and it shouldn't be taken in any way as suggesting that claimant and defendant representatives don't know what they're doing or need some help. That is most certainly not the case.
Absolutely right. Of course they do, but sometimes people say, "Oh, the mediators, we only get the difficult cases, and there's a reason why the case hasn't settled, and we're here to assist to get beyond that reason, really." So that's what I'm meaning by that. But thanks for that observation, Tim. Thank you. There's no questions arising, so Paul, if I may, I'll ask you to talk to us about position statements and the necessity or otherwise of them.
Okay, thank you very much, Phil, and hello, everybody. One of the joys of being a mediator, as in any branch of our profession, is that as we get more and more experience in the work we do, we're always learning. And both I and my colleagues have learned an awful lot in the thousands of mediations we've conducted so far as to the utility of what is called a position statement. So what a position statement is best described as what it is not. First of all, it's not a pleading. It's not a rehash of the pleadings, and it's not a case summary. The whole intention of a position statement from the mediator's point of view is to encourage the parties to drop their adversarial hat and start thinking resolution. How is this particular case going to be resolved? How is this particular case, from your client's perspective, going to pan out in the informality of the negotiations during the mediation? So Parties often ask me, now that we raise the issue of position statements in our introductory emails and during our pre-mediation calls, what format do I recommend? And the answer is, it's whatever is suitable for your client in the particular case. And it isn't a tick box exercise at all. It's the encouragement to you to sit back, drop away from the adversarial black and whiteness, and look at the grey areas that may lead this case to being resolved. Use it to set the atmosphere for the day and set out your agenda for resolution. It helps if you identify the key issues and what your position is, and equally important, set out what your understanding is of the defendant's position, because it's amazing the number of times that there are misunderstandings and misapprehensions here. And I vividly remember a mediation face-to-face, which lasted less than half an hour, when in the introductory session, it became blindingly obvious that the defendant had totally misunderstood the way in which the claimant was putting its case, and asked for the matter to be adjourned so it could review the whole issues. So that's one important suggestion. Of course, we as mediators have no power to order anything. So anything I say is simply an encouragement and a series of suggestions. So do discuss, if there's been, for example, a joint experts meeting, how the conclusions of the joint experts affect your client's position and how you perceive them affecting the defendant's position. Do reconcile schedules if that's not already been done. An enormous amount of time is spent by the parties and the mediator in comparing apples with pears. Schedules are traditionally not exchanged, so run at different times, often using different language. And quite often there is misapprehension involved, with one party describing one head of claim under one heading and the other supplying it under a different heading. Use also the position statement to bring your opponent and the mediator up to date with developments. It could be further treatment, it could be further job promotions or loss of jobs, or accommodation changes, or family changes, whatever is new that you think impinges upon the way in which this case is going to be resolved, and it will be useful for your opponent and the mediator to know. The other use of position statements, which we've seen coming into play more and more in the particularly emotional cases, the fatal cases, for example, is use, if you're a defendant, or consider using, if you're a defendant, the position statement to set out what you would otherwise put in more strident terms in your counter schedule. We all know that there are many heads of claim that the man in the street, particularly in fatal cases, thinks it's obvious that the defendant should be paying for, which the law simply doesn't provide. So rather than increase the emotional deficit in a case by putting nil, not recoverable, whatever, against each item in the claimant schedule, why not consider setting out your sympathy, as there usually is in the position statement, and then indicate that there are some items generally in the schedule to which, as a matter of law, the claimant cannot recover, but indicate that you expect the claimant specialist solicitors to be able to advise the claimant on that, rather than you ram it down their throat. Identify risk factors. Excellent way of doing that. Set out in the confidentiality and privilege arrangements that every mediation is covered by, what you think is the real risk of either breach or causation or individual items of damage claim. and identify along with that how you see either the claim or the defence resolving those issues. It's always a very good idea as well to express your general intention to attend the mediation in a positive mode. It's your client's intention, hopefully, to resolve the issue. Emphasize that you attend, if so instructed, in a spirit of compromise and resolution. But in a case of no offers, tread really carefully in what you explain to your opponent. If you're a defendant instructed to use the mediation to secure a discontinuance, it's our strong recommendation that you use the position statement and hopefully documentation before then to alert your opponent to the fact that that is the intention and that is the reason you are attending. But in your position statement, consider using in plain language why you think the claimant's case fails and what it would take your client to change its views. And if it be the case that you're so instructed, indicate that you're there to listen and have the capacity and authority, if appropriate, or means of getting authority, to change your view if the discussions in the mediation should warrant it. So there's no standard format. There's no standard way of dealing with it. There's no standard way or timing for doing it, except my recommendation always is do it as early as possible. Put your resolution hat on as soon as you've booked the mediation, not on the night before or the morning of the mediation itself. And consider how you're going to deal with that position statement. There are two kinds, open and closed. Hopefully, most position statements are going to be open. That is, you're revealing information as to your view of resolution to both your client, your mediator, and your opponent. And my recommendation, and others may differ, is that don't get het up about whether it should be exchanged or not. If you intend it to be open, send it to your opponent, whether they're ready or not to give you their version. They may never do so, but you have set the table for the resolution process, and hopefully you will have prompted them also to put their resolution hat on. The other form of position statement is closed, for the mediator's eyes only. And one hopes that it'd be fairly rare that you will want to provide information to the mediator that you wouldn't provide to your opponent in the confidentiality of the mediation process. But sometimes they're really useful to tip, for example, the mediator off that maybe the claimant doesn't actually know the life expectancy. Maybe there are special family or beneficiary dynamics that you want to draw the mediator's attention to. So you prevent the mediator treading on eggshells, as it were. Maybe it's the last thing that your client wants to go in front of a judge, emphasize to the mediator that when talking to the client, encourage the client, if that be the case, to tread the resolution path and not be set on going to trial. As it's still the case that many claimants in particular feel that mediation robs them of their day in court. So that's my view. Others may take different views, and I'm sure my colleagues have ideas that they've picked up and recommendations they can make. So I'll step down and hand over to anyone who wants to chip in.
Thank you, Paul. You're talking about a closed or private position statement just for the mediator. If it's an open position statement, and say I'm the defendant writing this, who am I thinking is the primary audience for this document?
Well, you're hoping it's going to find its way to the claimant. That's why I use the words in plain language. That's why I use the words about the use of the position statement to deal with controversial issues in a less abrasive way. So I think the way you should, as a mediation advocate, set your store out in a position statement is not to use legalese unless it's absolutely necessary, not to think you're sending the words direct to the lawyers, never to see the light of day with the claimant. You want to encourage your opponent to seek appropriate instructions from those instructing them. Now, obviously, the dynamics are usually different on the defendant side, but even then, there are any number of cases where the defendants, even in medical negligence or personal injury cases, are real people.
Thank
Paul,
you.
question from me. What about the timing of position statements? Obviously not to be handed over on the morning, but when would you advocate they be sent?
Or the night before.
You might think that's an obvious point, Tim. I have had position statements handed over on the morning, and it's a disaster, an absolute disaster, and a waste of time. So I recommend, and I think I did say this, as early as possible that you can think resolution. And when you're ready to serve the position statement, do so. Give your opponent time to mull it over, time to respond if they haven't done a position statement of their own, and time to seek instructions. Certainly not on the morning, certainly not on the night before if it can be avoided. I'll leave it to others to say how long they might need, and it will vary because we all know we can organise mediations, within 24 hours. So sometimes there's a long lead in to mediation. I think I'm currently booked to do one in June next year. So the party's got plenty of time to think resolution. But on other occasions, it may be a very short time. But use the position statement, as I said, to set your views on resolution and to move away from the adversarial atmosphere.
Thanks very much, Paul. There are no questions from the floor, so a reminder, if you did want to submit one, please use the Q&A. But I will move on now. I'll ask Andrew to talk to us about opening sessions.
Thanks, Phil, and good afternoon, everybody. Two sort of questions to pose right at the top of this short presentation. One, should we hold a joint opening session at all? And two, if we do, what is it that we, mediator and parties, are seeking to achieve from the opening session? Well, in response to the first question, should we hold an opening session? My answer is almost always yes. I'm sometimes challenged by parties as to whether it will be appropriate. The sort of challenge that I might get might be, well, we and it's normally the claimant, we don't want to be in the same room as the defendants. My response to that is that I think there is a huge benefit in getting together at the beginning. Paul has talked about changing the atmosphere from litigation and adversarial approach to one of thinking resolution. And I think if we can get people together, that is quite an important first step. Then I suppose it's worth thinking about whether it makes any difference if the mediation is being held online or in person. It's probably true to say that the majority of mediations are still being held online, although I have begun to notice perhaps a slight trend back towards mediations in person. The other potential is that you have a hybrid mediation where some people are online and others in person. But just thinking about a mediation where we have everybody in person, I think it is important briefly for the mediator to think about where the parties are going to sit. It's probably not a good idea to leave the claimant potentially sitting next to the defendant's advocate. On the other hand, it can be nice not to have one side lining up in battle lines facing the other. So that's something to think about. Another thing that as a mediator, I'm often faced with thinking about is, where are we going to hold at the opening session? Some hosts are very kind and generous and put the mediator in a glorious room with plenty of space and lovely views, and others slightly less so and find a broom cupboard for the mediator. In those circumstances, you're probably going to be using one of the parties' room for the opening session. And it's important to check that they're happy. It's important to give them the opportunity to tidy away any private papers. So just something to think about as far as the logistics are concerned. If you've got a hybrid situation, it's quite important that the tech has been sorted out. People joining online need to be seen, so the screen needs to be somewhere suitable. And equally, the people online need to be able to see and hear clearly those in the room. So again, just a logistical point to think about. Fairly low key, but I think also quite important is to think about how the parties wish to be addressed. My approach is to start with an assumption that people are happy to be referred to by first names, and many more times than not, that is the case in private sessions when parties are talking to me. But sometimes in an open session, the parties feel very differently and would like to have a more formal Mr. This or Mrs. That. So again, worth being clear as to people's preference and ensuring that the other team, in particular the other side's advocate, is aware to avoid upsetting anybody early on. So what's the purpose? What happens at the opening session? When I'm mediating, always take the opportunity to reiterate the ground rules. Phil mentioned it in his presentation, reiterating the confidentiality of the mediation, emphasizing the additional levels of confidentiality when in private rooms, and reiterating that this is an opportunity for people to be brave in a safe situation, and sharing with the mediator and indeed with the other side, perhaps more than they might in an open session. In the event that there is anybody attending the mediation who is not a party, I always take that opportunity early on to reassure people that those non-parties have signed a non-party confidentiality agreement, and that I think is quite an important reassurance. I think inviting everybody to introduce themselves and to explain their roles at the mediation is important. Defendants will often attend with a representative from the Trust, with somebody from NHS Resolution, and I think it's quite helpful for the lay claimant to hear who they are and what their role will be. So far as the advocate's opening is concerned, I emphasize that I think a better opening, or the best opening, is one that's short and sweet. I am keen for the parties through their advocates to set out what it is they're looking to achieve. But what I do not want to hear in the opening session is how they're going to achieve that. The risk of an advocate opening in that way is that you will simply invite a response from their opposite number, and you have moved quickly back into trenches instead of getting people out and about and talking. In summary, I think the opening session is about creating a spirit of cooperation, one of seeking resolution, and putting to one side the antagonism that almost inevitably will have built up over the course of the litigation. A potentially important part of an opening session is an impact statement on the part of the claimant. Now, an impact statement can be delivered by the claimant themselves. And if pushed, I think on balance, my preference is for that to happen for two reasons, maybe more than two, but two headline reasons. One, very often, I think the claimant likes to feel that they have actually been heard. And by then delivering that impact statement, that facilitates that. I think it underlines the sense of the claimant being at the forefront and at the center of the mediation process if they've been able to deliver an impact statement directly to the other side. What should that impact statement comprise? What I'm keen for a claimant to do is to be given the opportunity to explain directly to the other side just how this incident has affected them. How has it impacted on their family relationships? How has it impacted on their ability to earn a living? It can be incredibly powerful. And one of the ways that we see just how powerful it can be is in the nature and tone of response from defendants. Whether there's going to be an apology in a case where liability has been admitted or not, it naturally flows for most defendant advocates. It gives them an opportunity to genuinely respond in an empathetic manner. And I think that little bit of gentle choreography can help to create that right atmosphere that I mentioned earlier, that spirit of cooperation and seeking resolution. So I do think that an impact statement is important. I think it's important because it helps the claimant to feel front and center. And I think it's important because I think it does help the defendants to respond in that genuine way, which is important. And I've heard it many, many times, is important for the claimants to hear. There is an aspect of opening sessions that I think Tim just wanted to comment on. Tim, the headline is the Texas Mediation Guide, and I'm very interested to hear from you how that fits in here.
Well, the Texas Mediation Guide is a guide by a US, a Texan, would you believe, attorney, who has got a huge amount of experience of mediation. And we've learned from what you said, Andrew, and what Paul was saying before about the tone. And some people think this is a bit fluffy and woolly, and why don't mediators kind of get on with the real work, which is getting to settlement. And the tone and the atmosphere of the meeting, where the mediator is chairing, is really very important. And this guide, Eric Galton, the author, really brought it home to me, talking about the adversarial tone versus the mediation tone. And what he said was this, that well, at a mediation, you're not talking, you're not drafting to a court or to a judge. You're speaking to the other party. The audience is the client on the other side. And it's crucially important to the mediation, where you're there to try and work together to get a deal, to approach that in the right way. And what he had to say was this, that you are very often seen as the other party's lawyer, whether you're solicitor or counsel, as the enemy, someone not to be trusted. You can be disliked, often intensely. I'm thinking at the moment partially of the question in the Q&A, which is, what do you do if you've got a very aggressive co-defendant at a mediation? And some people behave like this. And in doing so, if they are aggressive and adversarial, they miss the whole point of a mediation, because when you're speaking to your audience, you want them to like you. And in fact, whether you're writing or speaking, Eric Galton suggests that these should be your objectives: to have the other side listen to you, to have them respect you, to aspire for their trust, or at least minimize the degree to which they feel threatened, to get the other party to feel you are prepared and professional, to get the other party to feel you are present to listen and have an open mind, to acknowledge to the other party that they may not agree with what you will say, but to express the hope they're open-minded enough to listen. This is not about what you say so much as how you say it. And getting the tone right, whether it's the position statement, as Paul has talked about, whether it's the opening statement, but it's your whole demeanour and approach to the mediation. This doesn't go to the substance of what you're doing, and you may have a very firm position on liability or on valuation or whatever, but it's how you approach it. And if I could just deal with the other limb of the question that has been put, and it is this: if you know you're heading to remediation where you've got another party who has been behaving and is expected to behave at the mediation very aggressively in an adversarial way, the first thing to do is to share that with the mediator. And forewarned is forearmed. And we do have to deal with parties from time to time who behave in this way. And if we know that in advance, there are measures that we can take to hopefully tamp that down to some extent, if not to persuade someone to take a different approach. Perhaps I'll pause there to see if my colleagues have got anything else to say on that question of how you deal with an aggressive, in this case, co-defendant, according to the question. How would you deal with that? Anyone got anything to add on that?
I was going to say if the person who asked the question wanted just to express whether they've been aggressive in a sort of physically aggressive way in their presentation, or whether they were taking an aggressive stance on their position and without being verbally or physically aggressive. So, but maybe we'll get some clarification on that. But Paul or Andrew, if you have anything to add.
Well, I have personal experience in my early days as mediator of two barristers in a personal injury mediation fighting in the opening session, literally fighting, which was quite incredible. And as mediator, of course, I'm not a judge and I don't have much power, but I gave them the red card and sent them back to their individual rooms, and then went to find out what had caused this fracas. And it turned out that no one had told me that there'd been a failed joint settlement meeting beforehand and a failed previous mediation. And when I delved deeply in each room, so what is this argument about? It turned out it was a total misunderstanding, and a misunderstanding triggered by claimants deciding not to disclose relevant witness statements on the basis that there hadn't yet been case management directions. And when I said, well, wouldn't it be useful for the defendants to actually see the witness statements which show they're wrong in their understanding? They said, oh, well, do you think it will help? I said, yes, it would. Took the witness statements into the other room, and half an hour later, the case settled. So that's how I diffused that one.
Thank you, Paul. We're about to move on to, I think, thank you very much, Andrew, for your input. We're about to move on to Tim and to talking about the role of the defendant or insurer or NHS Trust or clinician or defence organisation at a mediation. Before we do that, another question has just come in, though, asking if we've ever had, any of the panel, any reason to doubt the litigation capacity of a litigant in person during a mediation, and if so, how did we address that?
Yes, but like I just say, it's happened to me on one or two occasions where that question has crossed my mind. But I've really gone to that person's solicitor and just questioned them about it discreetly to see whether the issue has been raised. And
Sorry, Tim, it's about a litigant in person.
the thing in person, I beg your pardon. No, I beg your pardon. The answer is no. Then I've not come across that.
No, I don't think I can.
I've not come across it, and it does place the mediator in some difficulty. It's often run parallel with how do you deal with a litigant in person who you know ought to have legal advice. In other words, it is pursuing a hopeless case. You know it's hopeless because you're a lawyer mediator specializing in the field, but we're not judges. And reality testing a litigant in person is extraordinarily difficult without turning it into advice, which we're not allowed to do, certainly in facilitative mediations. The answer probably to help the defendants faced with such a person, as well as the mediator, is to try and turn the mediation into an evaluative mediation, so an opinion is given, but how many litigants in person will genuinely accept such an opinion and take heed of it is very difficult. In a non-clinical negligence case, I did once slightly step out of line and saying I really felt that the mediation ought to be adjourned for the litigant in person to get legal advice. And in that instance, the litigant in person agreed to the adjournment and went off and got legal advice, and then the mediation was restored with lawyers. I don't regard that as advising. I'm just using it as a form of reality testing.
Thanks, Paul. I think if I had serious doubts about the capacity of a litigant in person, then I wouldn't want the mediation really to continue, and I would seek a way to bring it to an end. Obviously, there's questions about how much I could tell the defendant room from what I've learned in the claimant room, but if they're pointing out the same things that we've all seen, for example, in a joint meeting, then there's no confidence breach there. But and it can be difficult explaining to a litigant in person that the reason why you're stopping it. So it is a bit of a minefield, but I wouldn't want the mediation to proceed if that was my considered opinion. Okay, thank you. Tim, we've 10 minutes left, so you take up that time and we can concertina my piece or use it another time.
Okay, well, I'll deal with this succinctly. Looking at the defendant's side of the table, so to speak, in the mediation, or the screens in a online mediation, attendance at a mediation by the legal team only is suboptimal. Conversely, if in a personal injury case, the insurer, the decision maker, the person with the check is present, that is important. And in a clinical negligence case, if it is a case, for example, against an NHS Trust, to have a representative of the trust and NHS resolution present at the mediation is ideal. I recognise from defence organisations, insurers, and so forth, from their viewpoint, that commercially and practically it's not always possible to have someone present. And if that is the case, then the second best is that they are present online through Teams or Zoom, and next best is by telephone. It's a very important feature of the mediation, which we learn as mediators, is the claimant feeling that they're being heard, whether that's whether their voice being heard in a joint open meeting, or knowing that in the other room, the offer that the legal team are just advised on is going to be discussed not just by the legal team, but by the people with the responsibility for the matter. Additionally, there are other aspects which the defence room can deal with as a whole much better if the defence is fully represented. And the person representing the trust, or maybe it's a GP surgery or a private hospital, in addition to being present and overtly listening to what has been said, they may be able to have input on one or more of the following: an apology, an expression of sympathy, an explanation of what went wrong, an explanation of the post-incident investigation and any remedial steps that have been taken. Some of these aspects are incredibly important to a claimant and the claimant's family, and can make a real difference when it comes to moving from a disputed claim into settlement. Also, more generally, an acknowledgement of the length and stress of the litigation process and some expression of sympathy about that. None of these empathetic statements need to involve any kind of admission of liability or causation or anything like that. They can simply be expressed as people, one person to another across the table. And they do make a very big difference to the feeling in the claimant's room that this case is being very fully attended to today, even if it has taken a long time to get here. The other thing, and this goes back to the open meeting, if the claimant hears from the defendant team that there is a desire to work hard to achieve a settlement today on appropriate terms, if that is the objective of the defendant, is setting the tone in a really important way. Finally, the other important part of the defence room is being there to give instructions. The claimant is there, and a claimant obviously can give instructions on his or her own case, and that's taken as read. But on the defence side, it's not always as straightforward. The optimum is that there is full authority in the defence room to settle the claim when that decision has been made. And again, in practical terms, that's not always possible. But where a third party needs to be referred to for authority to settle, perhaps the representative attending the mediation has been given authority up to a certain limit or on certain terms, but then something happens at the mediation and makes them and the defence team as a whole say, well, we actually need to go a little further to settle the claim. It really is very important to the integrity of the mediation process for there to be scope to obtain authority. And indeed, in the notes that we send out before mediation, we make it clear that the trust mediation is held on the basis that those attending either have full authority to settle or have, and I'm reading here, robust arrangements where required to seek authority from a third party during the mediation, after as well as during business hours. And in terms of the claimant being heard, this really is very important to know that there is the wherewithal, if agreement can be reached, for a legally binding agreement to be drawn up that day. So those are some of the things about the defendant team, and I often make it my business to particularly thank those who are representing the trust and the NHS resolution, because they don't often play a large overt role. They don't have a big speaking part, so to speak, so far as the claimant is concerned. They may be involved in giving an apology or having a discussion, but theirs is not a major role on the face of it. But I think it's an incredibly important part of the mediation process. And to me, anecdotally, I find there's a correlation. If there's a full defence team there, and there is not, that there is a difference. So those are my observations, Bill, and I'm happy to hear what colleagues have to say about that if they've got anything they would like to add. Paul.
Just one point. Several of us have mentioned today hybrid mediations. I think one thing that I've learned from bitter experience is that a hybrid mediation where one party is present with the mediator and the other not simply doesn't work. I find it places the mediator in a very difficult position. After all, we're the independent neutral, yet inevitably we're going to be ensconced with one party and not the other. And the dynamics are extraordinarily difficult to convey from face-to-face to online. I don't know whether you have experienced one, but certainly I vowed I'd never do one again. Fair enough if usually it's the defendant, half the defendant team are popping in and out and are on a screen maybe, but the lawyer's present, that's fine. But an entire team not there when you're face to face with the other team, very difficult.
It is difficult. It is difficult, Paul. I agree, but I will only do them if clearly the party that's not attending is fully cognizant of what's going on and that they agree and we can go ahead and do it. Because I just can't get away from the feeling that because I'm physically in place with one party, there's somehow a benefit to that party, and so I don't like to do them. But I have done them and they have worked. And of course, if we do have when we have a joint session, I'm in my own room at the venue and I'm joining the thing from team. I'm not in the room with the claimant or the defendant team. But it's a bit artificial, I think, and I just can't help feeling that there might be a doubt on the party that's not attending, that there's somehow a disadvantage, and anything that sniffs of impartiality or imbalance is problematic. I'm with you on that. Okay. Well, there's no more questions from the floor, but thank you for those of you who did submit them. I'll talk about preparing negotiation strategies at another time. Sorry, we've not got to that. A reminder that our next session, as Tim said, is on Wednesday, the 11th of December.
12th, Bill.
Pardon?
Wednesday the 12th, I think.
Okay, all right. It's that Wednesday. It says 11th on your notes. Whichever, people will know. And I will be sending invites out the rest of this week with the exact date on that. Okay. So thank you all very much for attending. Please do tell your colleagues that the recording will be available on our website in the next few days, and do share it with them. Thank you once again.